Hi, everybody. This is Attorney Wilberforce Agyekum. I just want to get on here and talk to you briefly this week about uh, requests for evidence and notice of intent to deny. Two communications that you may receive from the USCIS in regards to your case. Now, the request for evidence. That is basically the USCIS letting you know that your file or the documents you submitted is not enough or sufficient, or your case, your file is incomplete. And for some reason, they have questions and they require you submitting additional evidence in order for them to make a decision on your application or your petition. Okay. Now, when you receive this RFE, request for evidence, you don't want to put it aside. You don't want to wait on it because the RFE is time sensitive, and the USCIS does not make a lot of exceptions, if any, about missing a deadline for you to respond to a request that they have. Okay. So both the RFE, request for evidence, and the notice of intent to deny. Now, the notice of intent to deny, that is the USCIS essentially letting you know that they've reached a point in your case where they are intending to deny the benefit that you seek or the application that you have submitted. So now, both are kind of similar because in the NOID, typically they're also going to ask you to somehow cure the defect by responding with either evidence or some arguments or any other basis that may allow them to avoid denying your case. Both of these instances are adversarial in nature. In other words, you've gotten to a point where potentially your petition or application could be denied. And in the case where it is related to a green card, what that means that you may be facing deportation if, in fact, you do not submit the evidence requested timely, or you do not respond to the notice of intent to deny timely. Timely is the key word. And having the documentation that's being sought is very significant. If for some reason you don't have what is being asked, you need to still respond timely and explain what it is and why it is you are unable to provide the additional documentation or reasons why your case or application should not be denied. Again, if the NOID or the RFE is in regards to your green card or something that could potentially be detrimental to you receiving a green card, then this is where you want to be sure you seek and retain competent counsel, competent immigration counsel to handle the matter for you. Remember, when you receive these type of letters, it may be your last opportunity to convince a USCIS officer that everything is okay and there's no need to deny your case, and you are able to provide whatever requested documents or explanation or argument in order for the officer to be able to render favorable decision in your case. At Ivy Law Office, we assist clients all the time in responding to RFEs and notice of intent to deny. Now, again, even if you are able to submit what the officer requested, it's no guarantee. You may still end up receiving a denial notice. You can address that if that happens. But your first step is to approach the letter you received with seriousness that it deserves. Because if you miss the deadline to respond, it could be the end of the game for you. You may not have any other recourse. Okay. So that is when you really should reach out to counsel to assist you. It is not something you want to play with. Usually, a lot of times, clients will attempt to respond to requests for evidence or notice of intent to deny on their own. Not smart. And a lot of times, when that DIY lawyering goes wrong, that's when they call the real lawyers to take over. And at that point, you really have gotten yourself backed up and into a situation where it will likely be costing you a lot more to take care of the situation than it would have if you would have sought counsel right after receipt of such a letter of like a RFE or NOID. Okay, so yes, you want to take it seriously. Reach out to a lawyer that knows what they're doing, an experienced immigration counsel, and they can respond to you. We can respond for you and give you a little peace of mind because at this point, again, it's a serious time and you could possibly be facing deportation if the response is not done correctly and timely. Okay? So, if you need assistance responding to a request for evidence or notice of intent to deny, please give us a call. Give me a call. Call us at Ivy Law Office, 301 287 301 276 0887. I keep getting, I got a lot of numbers in my head. 276 0887. And you can also reach us at our website at ivylawoffice.com. ivylawoffice.com. Again, our phone number is 301 887 2000. You know the number. This live stuff is crazy. But yes, give us a call. Reach us on our website, and we'll be more than happy to assist you. Okay. And again, don't take this lightly. Okay, here we go. Now we have it. 276 0887. 301 276 0887. We look forward to hearing from you. Don't take these matters lightly. Okay? It's very serious, but we can help you. All right? Reach out to us. Have a good day. Bye-bye.